We're going to get a little geeky today. We talked about the Robert Hunter versus Cortland Housing Authority case, which of course was the big win in New York that said, according to Glenn Sotheby, federal district court judge, Northern District of New York, that it is unconstitutional under the Second Amendment and Nysurpa versus Bruin and Heller to ban Americans in public housing, whether they be disabled, poor, or elderly, barring them from having a gun as a condition of them being able to use public housing is unconstitutional under the Second Amendment. Now, we're going to talk about the teaching points here. I don't want to talk about the case. We've done that in a prior video. I want to talk about some of the technical arguments that you need to know to be the smartest person in the room to win for the Second Amendment down the road in other jurisdictions. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. Stay tuned for a new announcement about another book coming out very, very soon. All right, folks, so we've already told you about the Hunter versus Cortland case that said that public housing, this is a big win for the Second Amendment Foundation and others. Congratulations to all involved. Big win for the Second Amendment in the state of New York, said that you can now have, guns in public housing, at least in the Cortland Housing Authority. Powerful precedent by Judge Glenn Sotheby, federal district court judge in the Northern District of New York. Now, what I want to do in this video is to use this as a teaching point of some very technical arguments that you should be familiar with because they keep coming up and up and up, and they illustrate certain points that I try to educate on this channel, and that I want other YouTube channels and other people all across the Second Amendment community to understand these kinds of arguments so you all can make your arguments in your world, in your sphere, in your jurisdiction, on your channel, whatever it is. That's what I want. I want to force multiply this information so you guys take it and run with it. So the first thing I want to talk about is we've already discussed how just like in a war, you have to win individual battles. And individual battles may not appear like a big deal, but they actually, when they add up, they accumulate into big deals. And what I mean by this is every one of these little cases out there, they may appear little to you. They may be like, hey, Mark, what do we care about some win in the Northern District of Montana? What does it do for me in New York? What does it do for me in Florida? The answer is these things build up and allow other judges in other jurisdictions to rely upon it. Brick by brick by brick, you build your case for the Second Amendment, you build your protections for the Second Amendment, and next thing you know, you have a very powerful wall surrounding your constitutional rights. An example of this is exactly here in Judge Sotheby's decision in, of course, Hunter. Specifically, if you take a look at page 5 of this decision, here you have a 2019 case being cited. Now, this 2019 case being cited is the sort of thing that you probably might have even blown off and not even paid attention to if it came up in the local papers. It was a case from the United States District Court in the Southern District of Illinois. And you may be thinking, in New York, what do I care about a decision in the Southern District of Illinois involving public housing? And here you have in a case called Doe versus East St. Louis Housing Authority, 2019, there was a victory for public housing advocates and Second Amendment advocates because they try to pull the same game in Illinois by banning guns in public housing. And because of this major victory in 2019 that perhaps many of you have never even heard of, guess what? Here we have in the year of our Lord 2024, Judge Sotheby in New York relies upon this authority of Doe versus East St. Louis Housing Authority from 2019 in the Southern District of New York, in the Southern District of Illinois, to rely upon and win for New York. And you see how a victory in Illinois in 2019 helps give rise to a victory for New Yorkers in 2024. This brick by brick by brick build-up is what we're always looking for. And that's why when I say, if I say it's huge or big breaking news and it's a big win for the Second Amendment, you know it's true, okay? No clickbait on this channel. I don't need it. The bottom line is that if I say something's important, it's important even if it's not obvious. And again, here's an example of why. A 2019 victory gives rise to a 2024 victory because of the brick by brick approach. That's the first lesson to take away from this. Don't forget it. The second thing I want you to keep about is that when it comes to our Second Amendment rights, keep in mind the way the process works is you have the text first, Once the text is implicated, the right of the people to keep and bear arms shall not be infringed. Once that's implicated, don't forget that the word infringe means to hinder or to destroy, to hinder or to destroy. So any kind of restriction on the right to keep and bear arms is an infringement under the text of the Second Amendment. Once the modern day gun control law is implicated by the text of the Second Amendment, you know the drill. The burden shifts to the government, no different than in a criminal case where the burden shifts to the government or is always on the government to prove that you committed a crime beyond a reasonable doubt. And if they fail for any reason, the government loses, you remain an innocent person. You're not convicted of the crime. So too in the context of Second Amendment litigation. When the text of the Second Amendment is implicated, the burden shifts to the government. And what is the burden of the government to do? How does the government possibly satisfy that obligation to justify modern day gun control law as consistent with the Second Amendment? The only way out of that situation for the government is to show that there are actual laws on the book at the time of the founding, in the time period of 1765 or so through the early 19th century, that window right there in the founding period. If there's not long-standing and robust number of historical analog laws restricting guns in some particular way, again, the example I always like to give is you cannot use a gun to commit cold-blooded murder in the 21st century. Why? Because you cannot use the Second Amendment as a defense to that, even though you may have used your right to keep and bear arms to commit cold-blooded murder, because at the time of the founding, everyone understood that yes, you had a right to keep and bear arms peaceably and to make sure you protected yourselves against all forms of tyranny, whether it be foreign invaders, domestic insurrections, street criminals, animals, whatever, hunting, so on. You could not use a gun at the time of our founding, cold-blooded murder. That is understood in every jurisdiction from before the founding through today. That's the kind of long-standing restriction on one's right to use a firearm that is understood to be perfectly consistent with the Constitution and doesn't violate the right of the people to keep and bear arms. That's an example I always like to give. So if you're indicted for cold-blooded murder, you can't really argue the Second Amendment defense to saying I have the right to keep and bear arms, and therefore I can commit cold-blooded murder. There's no historical tradition there. In fact, the historical tradition goes just the opposite way. Now, the reason why this is important, and this is the critical takeaway I want you to understand, extremely important what I'm about to say. Famous Sherlock Holmes story about the dog that did not bark in the night. The dog that did not bark in the night. You can look it up. Very famous way that Sherlock Holmes solved a particular mystery of who done it, the dog that did not bark in the night. This is another way of saying that silence speaks volumes. Now you're like, Mark, why do we care about the dog that did not bark in the night, or the concept of silence speaks volumes? Well, the answer is because in the context of this situation where we talk about applying and interpreting the Second Amendment and applying it to real world modern day gun control law, if there is historical silence, if our founding fathers did not bark in the middle of the night, so to speak, about gun control, it means that the government loses. This is extremely important to understand this, because the anti-gun movement and some judges that are sloppy or ignorant, or you insert the description you want for those judges, they are trying to argue, especially this is what the anti-gunners are trying to get to, that even if there's an absence of laws at the time of the founding about a particular topic, that doesn't mean they lose. But the answer is constitutionally, under Bruin and Heller, yes, it means exactly that. If there's a lack of laws at the time of the founding that justifies the modern day gun control law, that lack of laws constitutes silence that speaks volumes, or the dog that did not bark in the night, or the founders did not bark in the middle of the night, if you will. And guess what? It means the government absolutely 100% loses. Great example of this in this Judge Sotheby decision out of the Northern District of New York involving Hunter versus Cortland, the housing authority issue. If you look at footnote number 8, here's an example. Judge Sotheby says that the defendants do not discuss any historical analogies in their opposition papers or during oral argument about whether or not there's a historical laws on the books that prevented people from having guns in so-called public housing or alms projects or Christian charitable projects, poorhouses, whatever you want to call these Dickinsonian kind of concepts of how we took care of those that were not able to take care of themselves. There's no historical analog. Now, here's the key: the dog that did not bark in the night, and Judge Sotheby uses it correctly to great effect in this footnote number 8 of his opinion. He goes on to write that furthermore, the court has found no historical regulations of firearms in almshouses, poorhouses, or poor farms, despite its search for them in the Duke Center for Firearms Laws repository of historical gun laws, signed to the Firearms Law Center at Duke. So there you have it. Judge Sotheby, by virtue of the lack of laws, shows that there is no historical tradition restricting guns in poorhouses or public housing or anything of the sort, like there is, again, laws that basically prevent you from using firearms and all weapons to commit cold-blooded murder. See the distinction? So unlike what the anti-gunners are trying to do, which says that, well, even if it's silent, you can drag in some Ivy League history professor that'll say that, of course the Founding Fathers like lots and lots of guns control law. That's obviously absurd, but that's exactly what the anti-gun movement wants to do. They want to trot out an infinite number of, tenured professors in all the Ivy League schools, probably will trot out former president of Harvard, Claudine Gay, to say such a thing, that of course the Founding Fathers like gun control law. They love guns. Of course they would like gun control laws. Of course they like guns, gun laws and gun restrictions. Obviously that's all nonsense, but there's no doubt they could find plenty of left-wing academics in this country to be trotted out and swear an oath that says exactly that. I have no doubt they could find them if they have the opportunity, but it really doesn't matter, because under the law, the lack of this historical laws on the books, which is a judge's job and a lawyer's job, is all we need to prevail in a Second Amendment case. And Judge Sotheby in footnote 8 illustrates that point. The only other illustration I want to make here is, you recall from this decision, if you watched the prior video, in the Supreme Court decision of Heller in 2008, remember, back then, the anti-gun movement argued that handguns were bad for self-defense. I kid you not, handguns were bad for self-defense. Long guns like rifles and shotguns were good for self-defense. After the Heller decision came out, they flipped their position, and next thing you know, you have the concept of assault weapons being AR-15s, and now you see the argument all around America today, which is handguns are good for self-defense, but rifles and shotguns are no good, and therefore we get to ban AR-15s. Now, in response to that, this is clearly ultimately not going to work, but nevertheless, let's talk about what happened in Heller. D.C. argued that they were allowed to ban handguns in the District of Columbia. Why? Because they allowed people to have other types of weapons to effectuate their Second Amendment. And the Supreme Court says this is a no-go. Now, Judge Sotheby cites to the language where the Supreme Court rejected that argument in Heller, and then goes on and shows where that notion from Heller actually came from. And you'll find this very interesting. In Heller, the Supreme Court wrote this in response to D.C.'s argument. Quote, "It is no answer to say, as petitioners do, that it is permissible to ban the possession of handguns so long as the possession of other firearms, i.e. long guns, is allowed. It is enough to note, as we have observed, that the American people have considered the handgun to be the quintessential self-defense weapon. There are many reasons that a citizen may prefer a handgun for home defense. It is easier to store in a location that is readily accessible in an emergency. It cannot easily be redirected or wrestled away by an attacker. It is easier to use for those without the upper body strength to lift and aim a long gun. It can be pointed at a burglar with one hand, while the other hand dials the police. Whatever the reason, handguns are the most popular weapon chosen by Americans for self-defense in the home, and a complete prohibition of their use is invalid." Powerful language from the U.S. Supreme Court in Heller. So, why am I reading that to you again? I'll tell you why. Where did that come from? Well, Judge Sotheby did a very nice job teaching us. That language, that argument, doesn't actually come from the mind, per se, of Justice Scalia when he wrote Heller. It actually came from a decision a year or so earlier, a case called Parker in the District of Columbia. Again, a D.C. Court of Appeals decision in the Parker case gives rise to the language you just heard in the Heller case. All related, by the way. This is all interrelated, but you get the idea. One decision, an opinion in Parker, gives rise to that decision in Heller. Here's what Parker said. Parker says, quote, "The District of Columbia contends that since it only bans one type of firearm, residents still have access to hundreds more, and thus its prohibition does not implicate the Second Amendment because it does not threaten total disarmament. We think that argument frivolous. It could be similarly contended that all firearms may be banned so long as sabers were permitted." Very close quote. See the connection. So here you have, in 2007, In the Parker versus DC case, the predecessor of Heller, the case before Heller went up on to appeal, the Parker case makes this comment that says, well, that means you can ban all firearms because the government could just allow you to have sabers, and that's just plain stupid. So here you have that argument about sabers in 2007 in the Parker versus DC case, and then a year later in the Heller case, which is the appeal from Parker, different name, you get the point. But Scalia then takes this notion, seen first in Parker, and then embraced, saying that simply saying DC, which is what DC argued, that we can ban handguns because we allow long guns such as rifles and shotguns is not an argument. Same notion as what the Parker case said, which is, hey, that means you can ban all firearms as long as you let people possess sabers for self-defense. Parker, D.C. Court of Appeals, rejected that notion. That notion was brought into the Heller decision in 2008 by Justice Scalia. And again, you can see how these bricks, how these early decisions give rise to later powerful precedents. So when we talk about big wins, you may think, why is that a big win, Mark? I don't get it. It doesn't impact me. Yes, it does. Because the Second Amendment, the whole Bill of Rights, the whole Constitution is a national compact. We don't want any of our team all across this great land, any of our citizens, to be adversely impacted by unconstitutional acts. And we're all in this together because, as you know, Benjamin Franklin once said, after the signing of the Declaration of Independence, if we do not hang together, we most assuredly will hang separately. And I think that comment from Benjamin Franklin made back in 1776 at the Declaration of Independence signing is a metaphor that holds true today. If we in the Second Amendment community do not hang together, we most assuredly will metaphorically hang separately. So there you have it. Hope it wasn't too geeky today. Make sure you follow me on X at 4Boxes Diner. Hope you enjoyed it. Don't forget to subscribe and resubscribe. A lot of people are getting knocked off the list here on the YouTube channel. And we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.